Welcome, everyone. So my name is Chief Matthew Cohen. I'm with the Richmond Police Department. I'm here with everybody here today. We're doing a presentation on information on how to interact with federal agents. My canine partner over there is Duke. He is a 6-year-old lab who's having fun up there. He wants to go say hi to everybody and come down to people's laps. So I have been doing some of these presentations around our community to help people learn what their rights are. This information is not legal advice, but it's information that's educational. Everyone needs to make their own choices and when they come into a situation, but the more education, the more information you have, the better informed you are to make your own choices. I do a presentation to keep me on track. For those who don't know me, I'll introduce myself a little bit more. So I've spent about 13 years working as a police officer in Williston. I then transferred down to the Richmond Police Department about a year and a half ago now. And then in October, I became the interim chief of Richmond Police. And so here we are today. Let's see, next slide. Is it going to work? There it goes. So I'm going to have some key takeaways in our slide here, which is, I'll come back to this, but these are my real big highlights on what we want to learn here. When you're looking at your documents, you want to verify what type of document, if an agent or an officer hands you a document, what it is. One of the big words you want to look for is a judicial signature, a judge's order. That gives the officer or the agent a lot more power than just an administrative document. One of the big pieces of when interacting with people is maintain a calm and professional demeanor. Doesn't matter who you're interacting with. If you're able to be calm and converse with the person that you're talking with, you're going to get more information, have more time to make a decision. Versus someone who is aggressive or confrontational. Sometimes officers will have to make decisions for their safety on a split-second decision versus someone who's talking back and forth. There's more time for officers to make a safe decision. And refusing a request, you can obviously refuse some sort of a request from an officer, but if it's an order, you need to actually follow that order. So that's one of the things, one of the differences. Know the difference between a request and an order from an officer. Doesn't matter. And I'll use officer, agent, law enforcement as a general term. So it kind of applies to all law enforcement. And Duke, come.
There you go.
Okay. Go lay down. Down. Okay. And then one of the things we can record and report interactions. So if you see something that you don't think is right, be a good witness. You don't always have to step up in that moment, but you can record it and report it back. And then one of my last big ones is, know your neighbors. If you know who's in your community and who your neighbors are, that can actually help when it comes to interactions. One of the things we have is our dual sovereignty. So when each state and each person, we actually fall under multiple jurisdictions. This is the federal jurisdiction, local, state level, all of these take effect. So federal laws are handled by the federal government. Our local laws are usually handled by local law enforcement, and these can be state laws or municipal ordinances. But when it comes from federal laws, the agencies get from they're following the U.S. Constitution. When we work on local laws, we're following the Vermont State Constitution. And they differ vastly in what our rights are under each, and what federal laws and judicial laws, judicial review, I should say, have been made in. So if the courts, there's one, an easy one is the Carroll Doctrine. So the courts in 1925, there's a federal law a federal case went to the Supreme Court, which said a car is a movable object, and if law enforcement has probable cause at that time, they can search it without a warrant. Now, in the state of Vermont, our Article 11, of our Constitution requires us to get a warrant. So we're not allowed to follow the Carroll Doctrine as Vermont law enforcement. We have to follow the Vermont law. However, if you're interacting with a federal agent, those federal agents are going to follow the federal laws. So even if they're in the state of Vermont, that the federal Constitution applies to them, not the Vermont one. So there are some of these differences, and that's where we drive a lot of our differences between what our interactions are happening with federal law enforcement compared to local law enforcement. The 10th Amendment, which is the anti-commandeering doctrine, basically says that the federal government can't force local and state law enforcement to follow and enforce their rules and laws. This comes back to, actually, it stems back to slavery and slavery laws and anti-slavery laws that took place in the 1800s. And it has been applied further going forward to today's world with ICE enforcement and immigration enforcement. So our local states, if local law enforcement doesn't want to enforce federal law, we don't have to. So we actually work in corroboration. Geez, I cannot talk this morning. in cooperation with federal agencies rather than them telling us we have to go do a work. So the way this works is like if we're working with, let's say, the DEA, we will ask them for their support. They can't call us and say, hey, we need you to go give us support. They have to work hand in hand. So kind of how this works in real world scenarios, because I will cover some like more real world versus what is on paper. Real world is if we're doing a joint investigation, and we call these joint investigations because both agencies are working together to come to a conclusion, which might be going after and arresting a drug dealer. So a joint investigation might be that local law enforcement, we might not have all the resources we need. It also could be that the federal agency like DEA might come in and say, hey, we have resources and information that says there's a local dealer in your town and we want to come in, but we need more manpower and support when we come in. So that might be a conversation we have ahead of time. And we can say, nope, we don't want anything to do with it, or we can say, yes, we can come help you. And they can do the same with us. So if we say, hey, we have a local drug dealer that we want help with investigating, they can say, sorry, we don't have the manpower, it's on you. Or vice versa, yes, we'll definitely help you out. So that's kind of how that relationship works, is it goes back and forth, which then goes back to under Vermont laws, when we interact with federal agents, especially when it comes to Border Patrol and ICE agents, we have a fair and impartial policing policies in place that actually prohibits us from interacting with federal ICE and border agents. Which just brings me to my next thing, the fair and impartial policing policies. So we shorten these to FIP in our world because most government agencies, we don't like to actually say everything out loud. We like to make it nice and short. In the early 2014, 2016 era is the early part of the FIP policies. Those stemmed from officers or perceptions of officers enforcing laws unequally and targeting certain minorities. And so it became the policy to make sure that law enforcement were not targeting minorities inappropriately. They're not going to go after a certain subset of groups. It doesn't matter what protected class it was. And the policies required law enforcement to report back to the state about what type of traffic. And these really stemmed off traffic stops. And what brought an officer's attention to a traffic stop, what brought him to interact with that person, and then reporting back on that data to determine if there was any sort of bias taking place. Act 54 in 2017 actually was a statewide adoption of that policy. And then in 2021, migrant justice came to act. I'm going to focus a little bit more on Richmond purposes only on this one, but in 2021, migrant justice and the Richmond racial equity group came together with the Richmond Police Department to actually adopt a model policy that prohibits the interaction with ICE agents. That was one of the early adoptions of not interacting with federal law enforcement in regards to immigration. And then in 2024, that a very similar policy to the one that was adopted in 2021 made it into the statewide policy, because they updated the statewide policy. And in 2025, we actually in Richmond adopted a more comprehensive policy that it continues to limit our interactions with federal law enforcement officers, which some of the model policies gave not loopholes, but situations where it was local law enforcement could interact with federal agents. Where now the Richmond 2025 policy, we have very little loopholes to interact with federal agents, and especially when it comes to immigration and customs enforcement. All right. So this is one of the eye-opening ones. And if you guys in the audience have questions as I go, please ask me, because me just talking back and forth to you guys, me just talking to you guys is not always the best.
Can you just talk a little bit about that? Can you just talk a little bit about that? Why do we want a fair and impartial policing? Why do we want to limit police officers' interaction with ICE, specifically around customs enforcement?
So typically, and I won't speak for everybody because I don't want to speak for everybody, but typically when you're interacting with someone from in relations to immigration enforcement, they are a subgroup in our society, in our group. So Vermont, we have, it could be someone of color, it could be somebody of a different background, and they don't want law enforcement to focus our attention on an individual because of their background and physical characteristics, things like that. We want us to enforce our local laws and focus on that. So when we enforce our local laws, and we want to do that fairly and equitably across the entire population of Vermont. So we don't want to pick one subgroup of our population and say, hey, we're going to focus on this group of immigrants that have come over. It could have been here legally too. We won't have any of that information. Interact with legal status immigrants looking for illegal immigrants. So the policy has moved on to, we want law enforcement just to look at our Vermont laws and enforce them equally across the board. And part of that would then, if you are looking at a subgroup of population, it would lead to other bias in policing. So if we have, we want to be non-biased in our policing. We want to just, if you break the law, you broke the law, and we're going to interact with you because you broke the law, and here's your outcome. And now all those should be equal across the board. Doesn't matter who that person was that broke the law. And we don't want somebody who identifies as a minority group to say, yes, you're only interacting with me because of my minority status. And because of that, I'm now facing this consequence that someone who is not a minority did not face, because you did not look at them because they're not a minority. Like, it's this whole group circle of answer to that question of, we want to be fair in our policing, we want to be fair in who we interact with, and we want to make sure that everyone gets the same treatment and the same opportunities for both corrective of behavior and outcomes coming out of so if I pulled someone over for speeding, and it's 10 over, and I'm giving them a warning, I'm giving that same warning to the person, no matter if they're male, female, what skin tone they have, what ethnicity they have. That it's all going to be given out the same way. And we're collecting that data to also verify that this is happening. So we're making sure that, yes, we did 2,000 car stops this year. Of the 2,000 car stops, 3% were of a minority. Of that 3%, only 50% got a ticket. So of those numbers, and that equals the same 97% of non-minority individuals with car stops, 50% of them got a ticket. So we're not seeing different outcomes for the different groups of people. That's one way we keep these numbers in check.
Does the federal government not operate that way?
I don't want to report on anything that I don't have personal knowledge on. And so I don't know what numbers and data they are collecting and reporting out. But so that'd be a great question for a federal agent and what rules and policies they follow. What I can say is, and I cover this in a further slide down, but I'll touch base on it now. Some of the recent changes in law from the judicial level have now allowed federal agents, when looking at immigration, to use personal characteristics. These are, language spoken, skin tone. I forget what the other ones that they are allowed, but they actually now are allowing these personal characteristics to be used to build reasonable suspicion for an officer to engage with them. So we can't, in Vermont law, we can't use any of those personal characteristics as a reason to engage with them unless they are specifically coming from a witness saying, witness A says, I have a male who is 6 feet with black hair, blue eyes, who left the store. We can then use that, but we can't just say, any male leaving the store. Like, that doesn't work. We have to have really specific identifying information. Where the federal agents right now, under that ruling, can use any Hispanic male leaving a Home Depot, can be used as reasonable suspicion that they may or may not be here to interact with them. It may or may not be here legally to interact with them, which is obviously inappropriate, in my opinion. I'll move on to the 100-mile rules. These are some of the eye-opening rules that we don't always realize we live within 100 miles of a border. So all these rules apply to within 100 miles of a border or coastline. And they give immigration enforcement and border patrol more power, I should say. And so my map up here is a rough estimate of where 100 miles is. And I will 100% say I stole it offline. So the accuracy of this map may or may not be 100% correct, but it's close. It's more of a visualization of where we are. There's really only a small subsection near Bennington and south of Rutland that in Vermont doesn't meet this 100-mile radius rule. And really what it allows Customs and Borders to search a car vehicles. It doesn't have to be cars. It could be boats. It could be trains, buses, trucks, planes. Basically, any mode of transportation, they can search without any reasonable suspicion, any warrants, anything. They can just search vehicles. That is within their rights to do so. Most of the time, you see this at border crossings and checkpoints. So when they say, "Hey, come over here, search," we're going to have you do a random search, they can. That's 100% within their rights. They can fix checkpoints. These are border crossings that we see most of the time, but they can put that checkpoint anywhere in that 100-mile radius. So if they wanted to, they could set up a checkpoint in South Burlington, just because. And they can put up a checkpoint and check as many cars as they want. Anyone going through that area. Will they actually do that? Most likely not, but it is within their powers. Their agents can do roving patrols, so they can conduct random car stops while out on patrol. They do require reasonable suspicion, so that this is similar to us in the state level of when we interact with a motor vehicle, we need a reasonable suspicion of a violation, and their violations are more about border crossings versus what we look for as motor vehicle violations. They'll look for, is this a border crossing issue? So this might be there's somebody who crossed the northern border in a vehicle, didn't go through a checkpoint, and maybe they went through on foot and got picked up by a vehicle, didn't go through a checkpoint. And they have a reasonable suspicion that this vehicle that's near the border picked up that person. So they'll stop all the vehicles near the border. It's not used very frequently, obviously further away from the border, but it is used a lot right near the borders. So within a few miles of the border, that's used quite a bit. And then the other one is expedited removal. So if you are an illegal immigrant or an immigrant who's within 100 miles of a border, and law enforcement, federal law enforcement interact with you, and determine or believe that you have crossed within 14 days of the time they interact with you, the removal of that person is expedited. It goes much faster than the original, than if someone gets picked up in, let's see, what's St. Louis. We'll pick St. Louis because it's in the middle of the country. Let's say they get picked up in St. Louis, there's a longer process. Even if they cross within 14 days, outside the 100-mile radius, there's a longer process. I'm kind of going to switch gears a little bit and now talk more about requests versus orders. And this is really important information when coming to law enforcement. It doesn't matter which law enforcement agency you interact with. The basics of this is a request is non-binding, it's voluntary cooperation. Most law enforcement, we interact with the public through voluntary requests. We don't want to force anybody to do anything. We want you to comply and say, yes, this is, and give you your options, and you get a choice and you can comply with whatever choice you make. The order is when you don't have a choice anymore. We are telling you we need this problem solved, whatever that problem is, whatever that order is, and it's legally binding. So if the example I give to somebody is if we're walking across a sidewalk, there's normally a publicly open sidewalk, and on any given day, I could be standing there and say, hey, can you please walk to the left of me or to the right of me, not through me? And you make the choice. You can go either way. It's your freedom. But don't run into me. And that's your choice. You can go wherever you want. But let's say now I have a piece of evidence on that sidewalk and I need to preserve that piece of evidence. And you come walking down the sidewalk, I'm going to stop you and say, you need to stop now. I need you to go around the sidewalk to the left and avoid my piece of evidence. If you decide to not follow those directions, then I'm going to actually have to arrest you for not following those directions. And there's a difference. A lot of times it really is, there's a legal reason why I need compliance. And other ones is, hey, it's a nice day. I'm just standing here. Can you just not hit me? And other than that, there's no legal reasons for compliance. So that's the voluntary request versus like an order. And I've had someone ask me, like, can you give a different example? So we do this a lot of times when we ask people to step out of the car for field sobriety exercises. Okay, a lot of times it's a request. Okay, we can request you out of the car and say, hey, do you mind stepping out of the car to do field sobriety exercises? That is 100% a request. But if I say, I need you to step out of the car now, there's a very different wording, and I might tell you why I need you to step out of the car, or maybe say, hey, step out of the car now, you need to come with me. Like, there's that difference. And there's a bunch of rules that we on the back end of law enforcement work on when it comes to difference of a request and an order. And what I tell people is, if you have time, you can ask the question, do I have to? That's a very good question to ask. Do I have to? And is this an order? And those are very good questions to ask. And if the answer says, yes, you have to, or yes, this is an order, then the time to argue that, or if that was legal or not, is not on the side of the road. The time to argue that is in court. And a lot of times, it's better to say, what was my wording on this one? I do not consent to this order, but I will comply with it. So there's that difference of, I don't agree with you, but I will comply with you. So it gives you that objection, like I object to your order, but I'm going to comply. It makes it known that you don't want this to happen. And then if that order was illegal, it'll come out in the courtroom. And that's where it comes out to say, okay, if it's an illegal order, then whatever evidence is found, whatever arrest happens after that, it gets thrown out. And then there's also civil liability that both the state and law enforcement have to handle if we violate someone's rights. Question?
And then with body cams nowadays and things being recorded, does that all become part of the record, that conversational interaction?
It does, and all the recordings come out and are used in the courts to decide what was legal and what was not legal. Also, if other witnesses are there and other points of view, I know in major cases, the whole area gets canvassed for cell phone videos, surveillance videos, and we see a lot of this coming out, especially in the media as requests come in. Well, you'll see different points of views of different major incidents, and that's because these different points of views are now being requested. The cameras are everywhere. It doesn't matter where you are. I will give Ring a little shout out because they have actually made it really easy for people to share videos with each other through the Ring community and with law enforcement if something happens, where we can put out a request, and it's all voluntary. It's a request. It's not an order. It's all voluntary. But people can say, yep, here's my video. An order is, if I wanted to go, say you do have a Ring camera on and you don't want to give me it, then I got to go get an order to make you give it to me. And that's what we call warrants. So what the difference with our forms, like a subpoena is a request for information. A warrant is an order for information. And a warrant is an order to search something versus subpoena is a request to search something. So one of the pieces of information that's actually on my forms here is no difference between a subpoena and a order. And really the order are the judicial signatures. So if it's been reviewed by a judge, you're being ordered to do this. If it's a request like a subpoena, an attorney can give a subpoena just because they're requesting information. You don't have to comply with a subpoena. You can say, I am not going to get. Here's the information I do have. I'm not going to comply with it. Go get a warrant. I will preserve my information for your warrant. Like, these are some of these conversations that we can have, but most of the time, I don't want to give advice. There are really no penalties when you don't comply with a request. So if you're not complying with a request, if I say, hey, can you walk on the left side of the road instead of the right side of the road, it's a request. There's no real penalties. But if I say, move over there now, and for whatever reason, and you don't comply with that, you can get charged with crimes and obstruction charges for not complying with it, or contempt of court for not complying with warrants. And a lot of times, requests are driven by agency policies and procedures versus an order is usually based on legal authority, the authority of a law enforcement officer, or the court's authority. All right. I really dive kind of deep into warrants and detainers if you want to know some of the differences about these documents. A detainer is usually, and when it comes to request, is a request. And this is, I will say, this slide and the next one was more geared towards, because I do these presentations for a lot of different groups, is more geared towards agencies and departments that are having to review this information and decide if they're going to let law enforcement in their building. So this is more towards letting someone into your building or your space. So not really the actual person being detained. So if there's a person that has a detainer, federal agents can actually stop that person from continuing to move and run away. But there's more about if they're coming to your home, coming to your building, and they show up with a order for a detainer, and you have someone who might be on that detainer inside or not. But you don't have to let someone in your home or in your building just based on the detainer. Now, if they have an arrest warrant, that's slightly different, because on the federal laws, if they have an actual warrant for a body, that gives them the ability to go into a building for that body. Under Vermont law, we need a warrant for the building and the body. So, a little different. So
if ICE came to the door with a detainer document, that Form 1 something, we don't have to let them in. Form 247A, I-247A. So they come to the door, they say, we have this form. We say, that's nice. We don't have to let you in. Is that
Correct.
right? Okay.
Now, they still might say, we're coming in.
And then what do we do?
You can object, but I would say, and again, this is educational, not you got
Sure.
your own legal choices, but I wouldn't put yourself in harm's way. So if law enforcement is forcing their way into a space, they think they have the rights to be there. They may or may not, but that person in that moment thinks they do. So that's where we go to the courts and we say, okay, did they have the right to be there? But in the short version, if you say, no, you can't come in, they say, we're coming in anyway, then at that point you say, I object to that. And if they still come in, you need to not put yourself in harm's way. That's that. They might think they have the right to do so, and I don't want you to think that you have the right. You might have the right to say no, and be in the right position, but get hurt because being right. I'd rather you be, object to it and safe than putting yourself in harm's way and getting actually hurt because of it.
This aligns with the procedures that we've set up, but we also added that we want anybody to document. So can you just speak to recording those interactions?
I do. Let me swing. There you go. What you guys can do. I'll skip ahead. So obviously we have the right to observe and record. This is our First Amendment rights. It's a protected activity. You can record people out in public, and a lot of this has to do with public versus private spaces too, which I can go back and cover some of that. But in public spaces, under the state of Vermont, as long as the person who is making a recording knows that they are recording, it's valid to be used in the court of law. So this is a single party state. So the idea is that one party has to know they're being recorded and that they are part of that recording. You can't just put a camera up and not be part of that recording in public. So, public spaces. I see a question.
Yeah, I'm not sure I'm following that exactly. You have to be part of the recording, meaning the person behind the camera needs to be in front of the camera and be part of that recording?
No, it's more about that person who is recording. Like if you have big, large cameras, you're doing it openly and obviously.
Right.
If you have a cell phone, you're doing it open and obviously. But if you're secretly recording, let's say you have a like a spy camera. Pen.
So it's overt. We've got a large 4K camera
Yes.
out there, and so if we're filming agents in public, interacting, doing whatever they're doing, it's obvious that we have.
And you're the person in the camera holding the camera doing that recording.
They can see that
that you're recording.
Okay, thank you.
That's good. All right. It's more about the covert recording of individuals, and if you're not part of that recording, let's say you put in a wiretap, is more of these type of things. You can't be doing like a wiretap on someone's phone. Let's say you tapped into someone's phone line, do some sort of virus. It's out there, and you listen into someone else's conversation. You're not actually part of that conversation, so that's not admissible in court. And it really is about admissibility in court, not about you're actually going to get in trouble for it. So, but yeah, so basically if you record individuals and what's going on, or you're a witness, we recommend that you stay at least 10 feet away so you're not obstructing the person or the federal agents, and that you basically maintain a safe distance from each other. And that distance might be further based on the situation. So if there's a riot or a protest that's getting out of hand and there's now tear gas going from people trying to control that, you might want to be further than 10 feet away because you don't get tear gassed.
Are there instances where federal agents would ask us to stop recording? And if so, what's the procedure in that scenario?
That's a great question. So they may ask that, but you can make a choice, right? You can choose to comply, and they might say this is now an order. You can say this is an order.
So once it's an order, then it becomes
serious. Your choice of, am I complying with the order, or are they going to make me comply with that order? If they're saying it's an order, then they're going to, if you don't comply with it, they're going to make you comply with it. One of the things that happens though, let's say you are recording something, and I'm not saying this actually happens in real life, but it could. If someone has their cell phone out and is recording an incident, I could go seize that cell phone as evidence and say, I'm seizing your cell phone because of the video you have on here as evidence until I get a warrant for it, and then go get a warrant for your cell phone to get. So those are recourses that law enforcement have. Do they do that? Not often. It depends on what happens. But if there's an incident that revolves in a death of somebody, and there's people right there are still recording, that might be a request to them to say, hey, can I have this video? If they don't, then what happens? They can seize that device and get a warrant for it. So it goes, recordings are protected, but they also might become evidentiary. And if they become evidentiary, then we have rules to follow on how to get that evidence. And again, I don't say it really happens very often, but it could. I think the Boston Marathon bombing, they took phones from nearby individuals and they grabbed all live streams and things like that from, like, there are a lot of data that they took in during that to try to find the suspects. And again, that's a major incident. Lots of resources were put into something like that. Let's see here. The property owners and tenants, this is what we're talking about. They have to, you can ask the agents that come to your door or officers to actually show you the document they're using to enter your house. So is it a warrant or not? You can try to look at it and see and review it. If it's in the administrative documents, you have the right to say, I don't consent, and you please leave. Like, you can say, I don't want you coming in, and go away. Again, they may or may not agree with you, and they may think they have the rights to be there. But if they do, obviously we don't want to interfere with them physically. So, blocking an agent's path, touching agents is a felony. You can get arrested. I know what happened yesterday.
I don't know what happened yesterday. What happened yesterday?
You guys don't know what happened yesterday?
What happened yesterday?
It was in the news that the migrant justice, there was an ICE-related incident in Burlington, North End, maybe? South End?
Yeah. Oh. South End, there was some agents down there. Yeah, I didn't hear much about it, but I know there was some agents down in the South End. I got a text from my aunt, like in the middle of it, that somebody was shouting something like "Ice, Ice, Baby," getting the word out. And there were social media folks down there. Apparently, there was some images on Channel 3. Yeah, I don't know the whole details though.
Right, and so I don't know all the details either, other than what's been reported. But in the gist of it was that activists was able to go down to the South End and intercede on ICE-related activities. No one got arrested, so they must have been within their rights. Again, I don't know exactly what transpired down there. I wasn't there, but I know they interceded and stopped the interaction at that time. And sometimes this is where, if agents are, to say, going past or say, I need you to move, or I'm coming in, and you don't physically resist them. That's how you're going to get hurt. They're going to stop. You're going to say move, and they might move you to a place. But if you are physically fighting with agents and/or law enforcement, you have a risk of getting hurt. In the short version. Let's see. I'm going to go back because I'll go back to this one. So this is one of the new tactics that ICE and immigration agents have been using, and it's called administrative warrants. And I say new because they put warrant on an administrative form. It's signed by another agent, a supervising agent, not the agent that's actually on scene, but it doesn't have judicial review. But they have the word warrant on it. So there hasn't been challenged yet in the courts, so I don't know where this one's going to stand either, and what powers this gives federal agents versus what it doesn't. I just know it's out there. And this is what happens in law enforcement, in the history of law enforcement. A new tactic comes out from law enforcement, how it gets done. That new tactic goes into place. It gets actually used in the field. It goes to the court system. The court system reviews it and says, was this legal or was it not? Once it goes through the court system and the judges say, yep, this is good to go, or no, it wasn't good to go, then that tactic either gets used again and again or it gets stopped. And this goes across the board for any use of force. It goes across the board for any types of tactics. So when I say there's judicial law and there's the law on paper of what we have, from statutes from our legislatures, a lot of times the law as written gets changed by our judges as it gets reviewed and put in practice. So law enforcement has to know both what's on paper and what has been adjudicated. So right now, these arrest administrative warrants have not been adjudicated yet. So they haven't gone through the court system. They haven't gone through that test of what are they actually going to be legal and on what level are they legal. Because I bet you they are legal, but at what level of power do they give the agent? That hasn't been tested. Do they give the full level of a warrant versus a detainer? Because when they have a warrant, they have a lot more powers. I just want to make sure I didn't skip over anything. Yeah, I mean, this one I kind of touched base on a couple times, but I'll put it up on the screen so people have a chance to read it if they want to pause the video, because I know we're being recorded. If they want to pause and read this over, I'll put it on the screen for a couple minutes. But it's really just digs down into what is a judicial warrant versus administrative warrant detainer, and some of those powers on those. I'm kind of going to jump again to make sure I went back that way. All right. Protesting, because this is another big part of our First Amendment acts, First Amendment rights. I actually, as a law enforcement officer, like working protests because it actually protects the rights of those I'm interacting with. Our job is not to take a side in a protest. Our job is to protect your rights to protest and protect the rights of those who want to counter-protest your protest. So we have to protect both voices so they can be heard. And I actually, this is one of the pieces of law enforcement that I find that I can, me personally, get to protect both parties' rights. And I like being able to protect people's rights. Giving people the chance to speak their mind in a safe way, and so that way we can exchange ideas. And this is my idea of what democracy actually really looks like, is talking to each other and working it out till we come to a middle ground of everyone's upset, but we have a middle ground of what we agree with. So that's really my idea of democracy, and that's why I actually like working these protests. So one of the things, though, when you are protesting, you can't commit other crimes while protesting. So the rights of a protest to protest are there. But if your protest then goes to the level of committing another crime, that crime is still a crime. It doesn't, even just because you're protesting doesn't make that crime now legal. My example of this is usually vandalism that takes place as an act of protesting. Duke, come. Hey.
Get Duke some water. Is that okay?
No, he's good. Come here. Come. So every once in a while he says, we needed a break. Back here. Down. Yeah, good boy. All the way. There you go. Yeah, so going back, so you like there's a lot of times what happens is, you know, vandalism during a protest. The actual act of vandalism is still a crime, and it's not a form of protest. Protesting is with your voice. It's with your actions. It's not with defacing other people's property. It's not with going places that are not open to you. So again, it's open to the public versus not public. And I actually should touch base back on that on us with federal law enforcement. I can go ahead and go back. All law enforcement can go public places. So if it's a public space, law enforcement can go there. And this includes like walking up to your front door where a mail person could go. So if you get a package delivered to your front door, a mail person goes to your front door, your neighbor can walk up to your front door, law enforcement can go to your front door. Can we go around the back of your house? No. Do you not expect the mail person to go around to deliver a package around the back? But if you put a sign say, hey, deliver it to the side door, and it's around the back of your house, then law enforcement now can go to the back of your house too, to that where that direction is. So really, any place that's public, so again, this is like if we're in a park, or if we are in a street or road, any place that's public, law enforcement can go there. If it's open to the general flow of public, law enforcement can go there. So this is like if your building here that we're in right now has areas that's open kind of to everybody in the building and all the different tenants in the building. Law enforcement can go anywhere in the building. That's all open to everyone can go wherever they want to go without a warrant. Then when you get to private spaces, then you need warrants. So that difference between public and private space also translates back to protesting. Protesters can go anywhere that's public. If it's a private space, then they're trespassing. They can actually get arrested for trespassing. So, gotta know if you're protesting, what is your public space and what is your private space? I have a question.
So years ago, I believe it was Migrant Justice, they were having a milk protest outside of Hannaford's. Knowing inside the grocery store is a public space because everybody can go in there and shop, if I were a manager of Hannaford's, I wouldn't necessarily want the protesters marching through the store, disrupting other folks' shopping, but they have a right to do so?
So, a store invites you in and invites the public in individually under the law. So they have closed hours. They can tell people we don't want to do business with you. That's a right of a store owner. And so if someone who is part of a protest goes into a store like Hannaford's, they're good to go in, but then the store is also good to say, see you later. I don't want you to come back. And that happens quite a bit where someone will go into a private space and a private landowner will say, you're in my private space, you need to leave. And if that's when we usually get to, if the protest doesn't want to leave, then law enforcement has to force them to leave, and then you get people getting arrested because they don't want to leave for trespassing. They're not getting arrested for protesting, they're getting arrested for trespassing. And they get told to leave. And I will say I've worked these protests before where individuals actually will tell us, I'm not leaving, I want to get arrested. Like, as part of their protest is they want to get arrested because it brings more attention to the protest. And that's part of their choice, but that's their choice to make. We will give them the option to leave before arresting them, so that way they don't have to get arrested if they don't want to. And I say usually, it's more likely than not we're going to give them a lot of times. The other piece I want to add on with protesting is hate crimes. So the state of Vermont, we actually don't have a hate crime. I want to word this right. We have a hate crime law, but we actually don't charge anybody with a hate crime. The hate crime law enhances the penalty of a crime that you've already committed. So it's a penalty enhancement to a different crime. But when you are protesting, or if you're counter-protesting and you commit a crime, and the thing that you are protesting is a protected class, and that you can have a hate crime be charged if what you're protesting is against a protected class. Example, it could be a health clinic that treats a broad range of people, but the protest is against a certain group of people, mainly women, and their choices that they make. I don't want to actually put words in anyone's mouth, but that could be the protest. And during that protest, there's a crime that was committed against a protected class, a person of a protected class, that the person who committed the crime will get charged with whatever the original crime is, but also might get that hate crime tag onto that charge when it comes to sentencing. So it is really important that the other one is if two protest groups, protest one and counter protest are going at each other, and there's a physical alteration between the two, that might also get a hate crime depending on what the protest is about. So it really depends on situations, what's about, is it a protected class? If it is a protected class of individuals, then you can get charged if you commit a crime against that. Again, I kind of hit the police role is really to maintain a very neutral position on this. We want to make sure that we protect everyone's rights, and this is sometimes the other one is hate crime versus hate speech. I got to touch on this. Hate speech is a protected First Amendment right. hate and doesn't actually reach the level of a hate crime. So sometimes as law enforcement, we have to protect hate speech, which I really don't like doing, but it is a First Amendment class. But what we actually get to do is use hate speech when proving the hate crime. So your speech alone is not a crime. Your speech with actions is a crime. So this is where the freedom of speech, we do protect that, even though it might be hate speech, and it makes a lot of people unhappy. It makes me unhappy, but I still have to do it. It's protecting their right for that speech. But at the end of the day, if we can use that speech if they do commit a crime. So I didn't want to touch on that too. And I'm kind of back at the end of this, where I have our takeaways. And I wonder if my audience here has any questions of things I may or may not have touched on from our knowledge here. Anyone?
So when ICE comes to town, do they notify local law enforcement as a rule and say, come and help us, just to ask? Or do they just plow ahead and then you have already established that you're not engaging with them?
So because of our law in Vermont with the fair and impartial policing policy, that's a statewide policy, in general, they do not notify us. In other states where that policy doesn't exist, they may notify the local law enforcement and request help. But that's outside the state. So in our town, in our states, they will not be telling us if they're coming in or not. Which I know sometimes might become problematic when individuals want to verify if this is legitimate ICE-related behavior or just something that's not legitimate. We do have a way of verifying information, but we don't have a way of knowing ahead of time. So if someone says I think someone got picked up randomly, was this a legitimate, ICE-related activity? They can call the local agency. Our local agencies do have the ability at that point to then reach out and say, was this a legitimate ICE-related issue? And then point you in a direction of where to go, who to talk to.
Just a quick question. There's a lot of information, Chief. The 100-mile rule, how long has that been in place?
That's a great question. I don't have the actual answer to that, but it's
Since
been my
before
lifetime, I can tell you that.
9/11. Well, 9/11. Was it
Yeah.
before 9/11?
Yeah, it's been well established.
That's when I think we experienced it for the first time, because they would have blockades on the interstates within 100 miles.
Yeah, I probably can find the answer in about 10 minutes with a Google search, but I don't have that on top of my head.
Thank you.
Yeah, you're welcome.
We really appreciate your time and sharing this information with us.
Well, I appreciate you guys having me and being able to share this information. The more knowledge is more power. And I wish everyone a reminder, this is just knowledge-based. This is not legal advice. That you have to make your own choices when you get put in a situation like this, but at least you'll have some knowledge to back it up.